Welcome back to the courtroom where things are getting, well, permanent. We're starting with Haley Moy, a young woman whose face is becoming a canvas for her chaotic personal life. But beyond the ink, she's facing a serious felony for bringing prohibited items into a jail. Is she a victim of her circumstances, or is she literally finessing the system? Let's find out.
You've been missing your reporting.
Yes, I've been in and out of the hospital the past 3 weeks. Well, I left AMA by myself and I stopped taking my antibiotics and it got worse. And
There was a guy in court that you were hooked up with. Who was that?
my husband.
What's his name?
Cody.
Cody what?
Good ad.
You don't know his last name? Oh, you know what? His name is on your face. Each time you come before me, you have more and more tattoos.
I learned ones.
Oh.
You deprive your brain of oxygen when you do this. Perhaps you'll hemorrhage yourself. Perhaps you'll end up brain dead. You'll incapacitate yourself that you're going to be without the ability to speak. You do this, and then you get out there and it happens again.
For methamphetamine, opioids, and amphetamines.
Here's the problem.
Yes, ma'am.
You've been missing your reporting. Thank you. You've been missing your reporting.
Yes, I've been in and out of the hospital the past 3 weeks. Well, I left AMA by myself and I stopped taking my antibiotics and it got worse. And like I have PID, tubular ovarian cyst.
Notice how the judge pivots immediately from medical talk to the meth test. In a pre-trial hearing like this, excuses about hospitalization usually fall flat when you test positive for illegal substances. The judge is playing it smart. She's waiving fees because of the medical issues, but she's tightening the leash. Question for you guys. Do you think the judge is being too lenient by letting her stay out on bond after a positive test? Let me know in the comments.
And
So how does meth play a role in this?
it doesn't. I messed up. I'm not gonna lie.
All right, you're not under oath or anything, but how often are you using?
I really don't. That's why I was asked her. I said maybe it's a Xanax. I took that method, but I don't do any of it.
Are you on medication for Xanax? Do you have a prescription?
No,
So you're still not supposed to do that.
I understand.
So here's the thing. Your attorney's not here. You need to report to your pretrial services officer today. Do you understand?
Yes, ma'am.
Ms. Ferguson?
Yes, ma'am.
I'm going to have you have the seat. And can you have Robert Geyer? That's her pretrial services officer. See if he can zoom in. No. Oh, yes, you're right. It's the attorney. It is Stephen Avina. So just have a seat. We're going to have your pretrial services officer zoom in. All right. Y'all wanted to reapproach on Escarino? Yes.
I forgot to mention.
Miss Haley Moe, we're going to have you come back at 1:30 for us to take care of this matter. So if you're not here at 1:30, what's going to end up happening is a warrant is going to be issued for your arrest. Do you understand? That's yes or no?
Yes.
All right. We'll see you back at 1:30. All right. If everyone can please whisper, please. All right. Officer Avina, if you can unmute, please.
Yes, Your Honor.
Hi. Thank you so much for zooming in. I appreciate it.
Yes, ma'am, of course.
All right. So before me is Haley Moy. And my understanding, you all had difficulty contacting her? Or basically you had no contact with her?
So on her initial reporting for orientation date, she did not report. However, on the 2nd of January, I was able to make contact with her and conduct her orientation.
All right. When is her?
Over her condition.
I'm sorry. Go ahead.
On the 2nd of January, I did conduct her orientation for conditions of bond.
All right. So when's the last time you had contact with her? Was it the 2nd of January?
No, ma'am. So on the 1st of February, I had contact with her and she informed me she's on bed rest. However, we've never received any documentation.
All right. So I'm going to give her a deadline to give you all documentation. And I am going to want her in outpatient treatment. And if you could waive the fees for that, because she tested positive in court today.
Okay. Yes.
So when are you going to have the documentation?
Yeah, I have an appointment next Wednesday with my doctor, and that's when I can get her handwritten. So right now, I'm just getting it on my chart from university. They don't let me screenshot anything. They said for security.
That's okay. So you're saying Wednesday, the 21st?
Yes.
All right. So are you able to schedule an appointment with her on Thursday or Friday, the 22nd or 23rd?
I can.
No.
call.
I'm talking to him.
Oh, okay.
So, Your Honor, you wanted her to have outpatient treatment. Is that correct?
Yes.
So I would actually have to submit a transfer to a separate section in our office. And that would be entirely based upon what they can do.
Okay. But before, so who would she, I want to make sure she reports and gives proof of the hospitalization.
Correct.
So can she report on the 22nd or 23rd?
Yes, ma'am.
All right. So what I'm going to do is I'm going to continue with bond conditions. I want to continue with the random drug and alcohol testing. There is going to be outpatient treatment. And I'll ask that fees are waived since she has these medical issues.
Mhm.
And she is to report with proof of hospitalization and medical diagnosis and treatment. No later than February 22nd. Is there anything else you need from the court?
No.
All right. Is there anything else she's going to need with you all?
No, Your Honor.
All right. Thank you so much for zooming in.
Yes, Your Honor. Have a good day.
Thank you. You too. So, Miss Moy, who brought you down here today?
My husband's mom.
No, there was a guy in court that you were hugged up with. Who was
My
that?
husband.
All right. So, if he were drug tested, what would his results be? And let me just tell you, I'm not even.
This is where it gets awkward. Haley claims she's with her husband, but can't even remember his last name. Then we find out his nickname is tattooed on her face. But she claims it's not his last name. The judge sees right through the Cody Banks mystery. Legally, the judge is about to issue a no-contact order. Why? Because you can't get sober while living with your dealer or your using partner. It's a bond condition. Break it and you go straight to jail.
It'll be the same as mine.
All right. So, this is the thing. You cannot be using drugs and be with a person who's using drugs. What's his name?
Cody.
Cody what?
Guerrero.
You don't know his last name?
Guerrero. I don't know how to say it. I'm not.
No. I mean, you should know your boyfriend's or husband's last name.
Guerrero.
Is he in the hallway?
Mhm.
Have him come in. Could somebody call Cody to come in, please?
Good judge.
Where are your parents?
They're not in the picture.
Do you have any family? Oh, you know what? His name is on your face. Turn to the side. Let me see what it
no,
says.
It's not
Cody.
Banks.
Is that his name?
No, that's not his last name.
Well, who is Cody Banks?
That's just what I got on my face. It's not his last name.
Okay. All right. What's your last name
Hello,
and your first name?
Cody.
And who's Cody Banks? All right. So you Cody Guerrero and Cody Banks?
Just the nickname.
You didn't know his nickname?
Well, I saw my face.
No. I mean, I asked you who that was. I asked you if that's the same person. You said you don't know. All right. And there's so your mother is the person who brought you both down here today and brought you all both from where?
My grandma.
All right. So you all are living with your grandmother?
Yeah, she has a house in the back. Yeah, city.
All right. I'm sure your grandmother doesn't want people living in with her who are using. So this is what's going to end up happening. And I want you to listen to me very carefully. If you need a place to stay, it's not going to be with him. I'm ordering no contact with Cody Guerrero or Cody Banks. And let me just tell you what the reason why I'm doing that. He's using, he's not under any type of jurisdiction of the court, so he can continue to use if he so choose. I don't recommend doing that because I don't think you want your grandmother or your mom to have to identify your body. You need to go somewhere and get into treatment. And whose name is over your eyebrow?
It's Vanessa.
Vanessa what?
Vanessa.
Finessing? What are you finessing?
Everything.
All right. Not doing a good job, but okay. So here's the thing. You are not allowed to live with him. He's in the throes of his addiction. You're in the throes of your addiction. And two people who are in the throes of their addiction cannot help each other. Because if you try to stop using, which you're going to have to, guess what? If he's using, you're going to want to use. And if you try to stop using and she wants to use, you're going to use because you're together. So you're not allowed to live with him anymore. You understand? Mm-hmm. So there's Haven for Hope. There's Salvation Army. They actually have a great women's program as well. And you can try Lifetime Recovery. And I'll add on here a referral to Lifetime Recovery. But you should not be with him. And do you have employment?
No, I received Social Security.
For what?
Schizophrenia.
I'm sorry, for what?
Schizophrenia.
All right. So you should not be coming down with her for this. You understand? And you all shouldn't be dragging your mother and your grandmother into this. All right. And you don't want anybody to have to identify your body because the last time you use may be the last time you use. And don't be going to hospitals and doctors to try and get medications when you really shouldn't be getting medications. Do not doctor shop, because when you doctor shop, if one of those doctors, for example, forgets to put something in a system or something breaks down with communication, another doctor could prescribe you something that could cause you to have your life ended. You understand?
Yes.
So I'm going to email Stephen Avena, and I'm going to tell him to add no contact with Cody Guerrero, Cody Banks, and a referral to Lifetime Recovery. And just as a side note, when you're doing tattoos of people's names on your body, there are only two safe choices. Your mom, because usually people's moms love them and they're always going to be there for them, and children. If you end up leaving him, guess what? Your boyfriend going to be asking, who is Cody Banks? You may be able to slide a little bit because Cody Banks is the name of a Nickelodeon show, but otherwise you're not going to be able to slide. You understand?
We're moving from a bond hearing to the actual plea deal. Haley is pleading no contest, which legally means she's not admitting guilt, but she's accepting the punishment as if she were guilty. The stakes? For years in prison. This is a massive turning point. She's only 26, and the judge is trying to offer a therapeutic community program. It's a last-ditch effort to save a life before the prison system swallows a whole.
All right, good luck to you. Make sure you report to pretrial services.
Other court date reset?
No, it's the same.
So for today?
Ms. Ferguson, if you can make sure she has a reset form so she'll know when to come back to this court, but you're going to pretrial services on February 22nd.
Yes.
And then you have a different date to come back here, okay?
Okay.
All right. And make sure next time you come in, tops need to be able to cover the stomach, okay? All right. Good luck to you. All right. And this is a plea to 2 cases?
Yes, Your Honor.
Each time you come before me, you have more and more tattoos.
I'm the only ones.
Yeah. Oh. All right. Court is calling 2024 CR 1853, 2024 CR 008966, State of Texas versus Haley Lauren Moy. Moy, could I have parties announced for the record for the state?
Antonio Ariola.
Defense?
Robert Gear, Your Honor.
And are you Miss Moy?
Yes, ma'am.
Counsel, have you received all of the discovery?
We have, Your Honor.
Did you review it with your client?
Yes, we.
Are there any applications?
No, Judge.
Court will find that the state is in compliance with discovery and each cause number. Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State and 1853, are you proceeding on the indictment as presented? It appears that you are. The evading.
For 1853, yes, we are, Your Honor.
All right, and 8966, are you proceeding on both counts? It appears that you're proceeding on count one only.
That's correct, Judge, and we'll wait count two.
Any objection?
No objection, Judge.
Ms. Moore, in each of the cause numbers, did you review the court admonishments with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
And the cause number ending in 53, you're charged with evading arrest, detention, vehicle. And the cause number ending in 66, and count one, you're charged with prohibited substance or item in a correctional facility. That's a third-degree felony. The evading in a vehicle is also a third-degree felony. Range of punishment in each of those cause numbers anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand in each cause number you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause number?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe that she does, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do believe so, Judge.
Ms. Moy, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
At each cause number, the court will find that the defendant has knowingly and voluntarily waived her right to jury trial. And each cause number, did you review the plea bargain pages?
Yes, ma'am.
And the cause number ending in 53, according to the plea, punishment is to be assessed at 4 years in the prison. There's a $2,000 fine. There are no applications. This will run concurrent with 2024 CR 008966. The state will take in consideration 2024 CR 1854. And there's to be restitution, if any, to Samuel Brazier, Brazier. And the cause number ending in 66, according to the plea, state is proceeding on count one. Punishment is to be assessed at 4 years in the prison. There's a $2,000 fine. There are no applications. This will run concurrent with 2024 CR 1853. The state will take in consideration 2024 CR 1854. Did you understand that to be the plea bargain agreements in each cause number?
Yes, ma'am.
Did you review the waiver of appeal paragraphs in each cause?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, in either cause number, has there been any such motions?
There have not been, Judge.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, in each cause number, do you have any evidence?
Yes, Judge, state offers State's Exhibit 1 with attachments under each cause number.
Defense is reviewed, Judge. We have no objections.
In each cause number, did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police report, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same for sufficiency.
Yes, ma'am.
All right, in each cause number, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Judge.
Anything you wish to say on behalf of your client?
Judge, we just respectfully request that the court follow the agreement statement.
All right. Then what the court will do is in the cause number 2024 CR 008966, court will find you guilty, sentence you to 4 years in the prison, give you credit for any time served. There's a $2,000 fine. Excuse me, Deputy. Yeah. All right, what the court will do, and that cause number, the court will sentence you to 4 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrent. This will run concurrent with 2024 CR 1853. I'll take in consideration 2024 CR 1854, and I'll ask for the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but maybe that can help you when you're released. And then in cause number 2024 CR 1853, the court is finding you guilty. The court will sentence you to 4 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrent. This will run concurrent with 2024 CR 008966, taking consideration 2024 CR 1854. And there's to be restitution, if any, to Samuel Brazier. And I'll also request the therapeutic community. Again, the therapeutic community is there to help you if you have any type of mental health issues or medical issues. So if you serve 4 years, they won't keep you because you haven't completed the therapeutic community. I do not have jurisdiction to force them to let you be in the program or to order them to place you in the program, but I think it's something that you probably need, okay? All right. And each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal?
Yes, ma'am.
And did you understand it and sign it?
Yes, ma'am.
And each of the cause number, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. How old are you?
26.
All right, you're 26. You still can turn your life around. When you were young, what did you want to be when you were thinking about what you could be in this world? Oh, what is it?
I wouldn't.
Okay, I hope it's not. Were you around when Julia Roberts had her movie out?
No.
All right, I'm just saying that because there were some people in my school, they're like, oh, I'm going to be Julia Roberts. And I was like, that is a crazy idea. But here's the thing. What I'm telling you is you still have a chance. You're not in the twilight of your life. I'm in the twilight of my life. So you still have more of your life in front of you than behind you. So you're going to have to make some changes. And this whole thing with inserting drugs and going to the jail with it, you could have died. And then the person who, this is how far addiction will take you, right? The person who got, had vomiting and everything, they actually took some of that drugs from you. That's what they're saying, that you uninserted it and gave them some and they got sick. So when you think about that, when you get clean and sober, you're just going to be like, who would do that, right? So when you go to prison, if I'm still here, when you get out of prison, if you need a place to stay, of course, you won't be staying with me, but if you need housing or you need help with drugs or whatever, you can come back here and I will pick up the phone and find a place for you, okay?
Okay.
And do not put any more tattoos on your face, okay? And don't get involved with anybody who wants you to put their name on your face. You understand? All right, good luck to you, okay?
Okay.
Now for something completely different and heartbreaking. Meet Mrs. Mansky. She's 65 years old and addicted to dusting, inhaling computer cleaner, This isn't your typical drug case. This is a volatile chemical abuse case. She was found slumped over her steering wheel with the engine running. The legal challenge here? You can't drug test for duster easily, and you can buy it at any Office Depot. How do you stop someone from buying a household item?
Thank you, Judge.
You're welcome. Do you have a dismissal?
Yes, Judge.
Is because you picked up a new case and you picked up yet another possession or use of an abusable volatile. I don't even know what happened because today is the day set for arraignment on this case. What happened on the new case, if you don't mind?
Do you want me to repeat the job?
Yeah, please, because I have not even heard it to know what happened.
Yeah. I also spoke to the witness yesterday, so I think 20 minutes.
Great.
But on October 17th of 2024, officers responded to a welfare check at the Dollar Tree located at 14324 and 2920. A witness stated she observed the defendant inhaling from a can of multi-purpose cleaning duster and later observed the defendant slumped over on the steering wheel of her motor vehicle in the parking lot. Upon officer's arrival, officer observed the defendant sitting in the front driver's seat of her motor vehicle with the motor vehicle running in the on position. Officer also observed several cans of multi-purpose cleaning duster beside her. Officer observed the defendant to be confused and disoriented. She admitted that she had entered the Office Depot to purchase several cans of duster with the intent to inhale chemicals in a manner contrary to the directions, cautions, or warnings appearing on the label. And the defendant stated she did so to create or induce a condition of intoxication, hallucination, or elation. And she was found in possession of 3 10-ounce cans and 1 3.5-ounce can.
Is there anything else that you wanted to add to this?
Me, Judge? So the witness who spotted her, she had pulled into the Dollar Tree, parked there, and the defendant's motor vehicle was right next to hers, and she had noticed that it was on. So the witness, she went into the Dollar Tree, then went down to Target, did some shopping, came back an hour later and noticed that the truck was still there and still running. So she got worried, looked through the window, and she found the defendant slumped over. She stayed watching her for a while to make sure she was okay. She didn't feel comfortable driving off. That's when the witness saw her lift her head up slowly and inhale from the can
Again
in front of the witness. And my witness, she told me, and then she slumped back down, and that's when the witness called 911 because she was worried about the defendant driving off in that condition.
I've spoken extensively with Ms. Stepanski about this, Your Honor. And
You said the exact same thing to me when we came here the first time, and now she has a new case.
it's true statement, Your Honor. And
How do we get her to stop?
well, in talking to the state, so the plea agreement that we have agreed to with the state is the maximum length of probation to 2 years of probation. So that she'll be closely monitored during that time period.
I can't monitor her 24 hours a day, though.
Well, but she knows that she's, subject to, random testing or urinalysis and different things.
Still not going to show. I'm forbidding you from going to any store that sells this kind of stuff. You're not to go to any Walmart. You're not going to any Home Depot.
So she's also willing to sign a no driving affidavit, Your Honor, and so only her husband would be driving her anywhere. And so I think that her husband threatened her to divorce. I mean, I just moving frank, over this. If this ever happens again, her husband's divorcing her, is what he's told her, and is going to be closely monitoring her, and she's not driving by herself.
You realize that what you're doing is you deprive your brain of oxygen when you do this, and at some point perhaps you'll hemorrhage yourself, perhaps you'll end up brain dead, you'll incapacitate yourself, that you're going to be unable to without the ability to speak. But you do this, and then you get out there, and it happens again.
It scared me so much this time, and
I believe it. I believe it. I don't believe one iota. Nope. You sold me the same thing, not
I'm currently
months ago.
attending NA meetings, which I will continue to attend.
I think that, like I said, the combination of her not being able to drive to be able to go get this stuff and her husband helping to monitor that and the enforcement of the 2 years of probation and making sure that she knows that, you know, she's under
I have a sponsor.
surveillance, that I don't think it will continue to be a problem. I think that when there's been monitoring, there hasn't been a problem. This was, again, this is just me kind of pulling back the curtain here because we're entering a plea.
Sir Haddad, how do we get it to stop?
This is, man, I'm sorry, just if I could just finish that thought for a second.
Look, I'm all ears
Yes, sir.
with any recommendation as how to get it to stop, because I mean, it's not something that I can test that'll show whether someone's using or not.
Judge, at this point, I mean, I was hoping that the TRS would recommend something such as like that's like an intensive treatment made for women. That's
Yes, I mean, yeah.
thinking one might be a good place.
Figure out where the TRS is going to go.
Right.
I think that that's the best thing that we need to do. Yeah, I think that.
But my opinion, Your Honor, is that the no driving affidavit will cover or will fix the problem. This was when as soon as she started to drive, basically, it became the problem. You know, when the husband said, "Okay, you can drive," then she went to the store and did that. But without her being able to drive, and like I said, you know, the husband making sure that that's not happening, because again, he's not tolerating it.
Is the husband here?
He is not here today, but I can get him here if you'd like, Judge.
I mean, I think, Michael, I think you hit the nail on the head. I think what we need to do now, and Craig, I think what we need to do now is have her TRAS to see where we go, because we have clinicians that will be able to tell us how to tackle this problem, because I'm truly at a loss of how to get it to stop, because theoretically this is something that you can get anywhere, right? You can have it delivered through Amazon, right? So
Sure, but that hasn't been her MO of doing any of this. I understand you. I hear your
she's
words.
been able to drive.
I understand.
Right.
Well, she wasn't able to drive for a while after this happened or whatnot, and then it wasn't a problem. And then when driving resumed, and that resumed being a problem. So that's why I think
I don't know that for
the
sure.
no driving affidavit would fix that.
Ms. Brown?
I mean, I've explained to her that, you know, what she's signing up for, you know, is a lengthy probation. It's a 2-year probation with potential constant monitoring that whole time, plus whatever TRS conditions and every kind of help that they can, you know, help her with. And then, you know, that if she messes up in probation, that she signed up for, you know, 180 days in jail, you know, that's, you know, what she's understanding. I know that when she was in jail, she spent 3 days in jail on this new offense or whatever. And I know that that was a pretty devastating experience for her. She's, you know, 65 years old and, you know, takes a ton of medicines, which she didn't get and stuff when she was in jail. And I know that was a big deal. She's having panic attacks in jail and things. But I think the conditions that we've agreed to with the state are sufficient. I mean, I wouldn't have signed up.
I mean, I'd like to put on there no possession of any kind of volatile container that can be abused to get high.
The judge is laying down the hammer. You're killing yourself slowly by banning a 65-year-old from Walmart and taking her driver's license. The court is trying to create a physical barrier to her addiction. It's a desperate move for a desperate situation. What do you think? Can a no driving affidavit really stop an addict, or is this just a Band-Aid on a much bigger problem? Thanks for watching this breakdown of the justice system's hardest battles.
I want, you know, no going to Home or Office Depot, Walmart. Ma'am, I want you to understand that if I find you with another of these containers, and I don't care what you're doing, where you're going, who you're with, I'm going to put you in a rehab facility in the jail. And I mean, if that's what we need to do to get you to stop, I'm going to do it in a heartbeat. Do you understand? You're killing yourself slowly. That's all that's happening. And the problem is that everyone around you is suffering. What happens if you do this in the middle of the road while you're driving? I mean, God, if you kill someone, you get charged with murder. Is that the last thing we want you to do is to spend the next 30 years of your life in prison because of a drastic and catastrophic event where you kill someone. And in that kind of stupor state, if you're in a car, you're begging for it to happen. Okay, so I guess I'd like to do the TRAS to see where we go. So what we're going to do is I don't know how to move forward with this, Ms. Stefanski. So what I'm going to do is I'm going to have you evaluated by our clinicians to see what they suggest is the best way to go forward. So I'm going to have you meet with them, and I want you to be honest, because I want to move forward in the best way possible. If you're not honest with them, a motion to revoke can be filed. We'll put you in custody, and we'll do it next time in custody. I don't want to have to do that. So be honest in the evaluation. Be honest with yourself. I'm now taking away your privilege to drive for a year. You're not allowed to drive. You're not allowed to use be in possession of any kind of container where you can get high from it. And I don't want you to go to any Office Depot. I don't want you to go Walmart or any of these places that you can also buy these from. You understand?
Sir.
It's 180 days in jail, probated for 2 years. You will do Thinking for a Change, a DWI education class, 2 victim impact panels, a TS, with the conditions you must fulfill: substance abuse treatment, no breast test refusal, no drugs, no alcohol, guardian interlock so that we know that you're also not consuming alcohol, and a one-time donation of $100 to Matt. Is this how you understand the agreement?
Yes, sir.
I think the max is a year, right? On the first, it's a year.
For probation?
Yeah. For license suspension, I think the max is a year. I mean, if it was 2 years, if I can do 2, I'd rather do 2, because I think that I just don't want you to go anywhere near a car until this problem has been tackled. Do you understand, man? Do you have any questions?
Sir.
There are other things in life give you that kind of rush instead of using a can. You need to find another outlet. But cans, that's not a good way to go, because you're really going to sue some irreparable damage the last thing you need is to become a vegetable. And that's what invariably it's going to happen at one point or the other. How do you plead to the offense, Mr. Stefanski? Guilty or not guilty?
Don't.
I will find you guilty. I will send you the agreement. Is there anything else that you wanted to add?
Nothing else, Sean.
Michael, anything else, guys?
Just the other 2 cases.
Okay, so as a brief part of the agreement is this DWI, they're going to dismiss your other 2 inhalant paraphernalia cases as well, okay? All right, and wish you best of luck. We'll have you do the TRAS, and then I guess just give me a heads up when you do it, will you? And then, Craig, I'm going to reach out to you so you know. When we get it back, I'll let you know what it is. That way,
That's not.
that you know as well. They may say inpatient. I don't know.
Right, and you understand that. They could
Understand
give
that.
you inpatient treatment.
All right, man.
We don't know.
Best of luck.
Depends on what they feel like is appropriate.
See you soon.
Thank you for the chance.
Calls case People State of Michigan versus Julie Papachel.
Your Honor, I appreciate the court's accommodation. I had an opportunity to speak with Ms. Fong Fichan. I discussed bond violations that have come to the court's attention since Ms. Fong Fichan's last appearance before the court. Ms. Fong Fichan.
Now that, as well as the continued lie.
Of course, Your Honor. And Ms. Fong Fichan is going to apologize to the court, going to admit that what the court has been made aware of, her participation on a video podcast.
Okay, let's just get it all right, Mr. Warren. Here's the stupidity of this individual. I lock her in jail because she was lying to me and violating her conditions. One of her first calls from the jail leads to a podcast. Am I right?
That's correct, Your Honor.
But then gets here and runs a ruse that she's really making the calls regarding her 2 children. Then, so not only does that then go on social media, there's then another one on social media shortly after when she was arraigned, where she was violating her bond condition at that time. I've yet to figure out why she doesn't have a medical marijuana card if that's what she wants to do. But she doesn't, and then just continues to use. Lied to community corrections, then lied to me. So she gets put in, then makes within that week at least 41 calls that we could see, but there were actually additional ones. Then can't wait a day after being released. Violates my order again.
And Your Honor, that is my understanding of where we are today in its entirety. And Ms. Fong-Fachan admits to all of those things. She did go into custody. She placed upwards of 120 to 130 phone calls, one of which was to a podcast. And I think that demonstrates to the court that her statements that she learned her lesson in custody, it may hinder that because Ms. Fong-Fachan was laughing, joking on a podcast.
Oh, yeah, she was. She thought it was all a game.
Of course.
And guess what? You can think it's a game. It's a game with me that you will never win.
Understand.
Ever. No, I don't think you do.
Can't speak.
No. Your Honor, that was the first week she was in custody. The following week, she lost phone privileges. She was released from custody, at which point she came before the court, apologized for what happened leading up to that.
Lied to Mr. Feaster, so Mr. Feaster would lie to the court.
Your Honor, I think Ms. Fong-Fachan understands that pretrial release is a matter of grace, and that for her to remain on pretrial release, she has to demonstrate to the court she is going to comply with her bond conditions. She has had a turbulent journey on her bond so far. She's had several violations. There are renewed violations. She admits to all of those. She would ask the court to
including that the THC cookies, the time release THC cookies was a lie.
Ms. Fong-Fachan understands that that story is not feasible. That when you inspect the claim that was made at her first probable cause conference, that it doesn't make any sense. And she'll admit that today to the court. That a number of things she said leading up to this have not made sense and have turned out to be false. And when a person, anyone puts himself in that position, you have to tell lies and lies and lies to kind of undo what you've done so far. I think Ms. Fong-Fachan wants to ask the court for a clean start, to come clean as to...
I thought we did that the last time. This is almost the same spiel I was getting last time, right before she got out and on film drag.
Right.
God only knows why you'd be mixing anything with Red Bull, but what the heck.
Understood, Your Honor. And she did drink. There's a video of her doing it. She doesn't deny.
There is.
And what she's going to ask the court to consider is continuing her bond, upwards modification, that she be placed on a other monitor alcohol use, that she submit to ETG testing to monitor her alcohol use, and that she cease using social media while this case is pending. Ms. Fong-Fachan is serious about resolving this matter. She's serious about taking care of her 2 children. Daughters Maddie and Ayana have upcoming birthdays on the 28th of March and on the 2nd of April. I know
So it'd be horrible if she's in jail on their birthday.
It would, Your Honor.
But it doesn't seem to me that she was really caring about them all this time anyway.
No, Miss.
She would have never put herself in the jeopardy that she's in right now.
Of course, Your Honor. I know her children are her primary concern more than anything else, that she's asking the court in a final act of grace to permit her to remain out of custody, continue her bond with those motions if she comply. And Ms. Fong-Fachan can address the court and come clean about any violations of bond leading up to today.
All right, what does she want to tell me? Mr. Allen.
I just wanted to apologize for starting off with a bad start with you. I hope that we start over. I did my time for bond violation for 2 weeks. I messed up the first week the second week you revoked my phone privileges. I learned my lesson. I had some time to think about what I've done, and when I think it out, I did have that cup of alcohol on the podcast. I truly thought that it was just no smoking weed, but I didn't know alcohol was a problem. But now I know. I do not have an alcohol problem. I was just drinking.
How am I supposed to know that?
You don't.
You
don't.
That now you've learned your lesson.
I know.
Tell me how I should know that.
I know that anything that I say, you probably won't believe because we started off poor, badly.
Oh, and you lied.
Yes, Your Honor.
It's not just little lies, big lies.
Sure.
Every step you've gone, you've been lying. So tell me why I should believe you now.
I don't have a reason or any excuse to argue with that. I understand.
Your Honor, I think Ms. Fong-Fachan knows it's not about what she says, it's about what she does. And what she's done leading up to this has not instilled confidence in the court that she's going to comply. We're asking the court to give her an opportunity to demonstrate that she's going to comply with the court's orders and perhaps present herself as a candidate at the conclusion of this case.
I know you're upset at me.
Oh, I'm not upset because I definitely get to go home today. So I'm not really upset. Go ahead. What did you want to say? You just think this is all a game. That's what your problem is. You do. You think this is all a game.
I can say definitely I didn't take it seriously the first week. The second week after I stayed in, I had a lot of time to think.
About what?
About, my actions before, during, and now after the fact, even having a drink. And I guess if you want to put me back in jail, I deserve it.
Yeah, you do. You have a CPL?
Yes.
Lost it. You know why?
Not really.
Smoking and have CPL. That's probably another form you lied on. How bad do you want to make this get, young lady?
Can you say that again?
How bad do you want to make this get? Because if you want to take this thing and make it the worst experience you ever had in your life, I'll be more than happy to indulge you.
I don't.
So whose rules are we going to play by?
Yours, Your Honor.
Absolutely. Problem is, I don't know that you know how to do the right thing. I think somebody that lies as much as you do about everything, it seems, and just kind of does what you want to do. You've probably been doing this your whole life. And that's why you can't change.
Yeah, to say a couple of things.
Oh, absolutely. I'm sorry, Ms. Hughes.
I appreciate it, Your Honor. Your Honor said something very interesting. You've probably always been this way, so that's why it's so hard to believe. This behavior is exactly what this case is about. She's charged with R&O. She's charged with malicious destruction of a building. She went to her ex-boyfriend's business and kicked his front door of his business. The police arrived. She immediately started lying to the police. That she had got there, that she hadn't kicked in the front door, that she didn't know what was going on. The police wanted to conduct their investigation, so they asked her to just wait in her car. That's all they asked her to do. And can you just wait in your car? And she took this as an opportunity to defy them rather than just listen to them. She told them, I'm not doing nothing. I don't need to go to my car. They asked her again, please go to your car. She decided to cut off Officer Cunningham, not allowing him to speak. She said, well, you can either wait in your car or you can wait in my car. She said, take me to jail. Fuck it. Yes, go ahead. Take me to jail. So I instructed her to put her hands behind her back, is what Officer Cunningham's report says. She then began to verbally and physically defy Officer Cunningham to the point that Officer Baldwin, another anarcho officer, had to get involved. When Officer Baldwin approached, the defendant turned to Officer Baldwin and pulled her left hand away and said, don't make me swing on you, to a police officer. So yes, this is what she does. She lies and she wants to play by her own rules. So by continuously violating Your Honor's orders, this is just a game at this point. Your Honor, I'm asking that you remand her. I'm asking that her bond be revoked and that no bond be set this time.
Thank you, Your Honor. Ms. Fong Fachan, as the court knows, is a mother. She was previously employed at the University of Michigan, stocking shelves. She lost that job when she was remanded to custody, and I know that she is seeking reemployment. Ms. Fong Fachan fully understands that the consequences of her actions.
Does she, though? Does she? I mean, I don't know anything about what was necessarily alleged in the case other than the charges, right? And then to hear that recitation of what this case is about and then look at this defendant's behavior, does she really? And I don't know why these kids keep coming up as some shield, because it appears to me everything she's doing has nothing to do with them. She's just running her world. Go ahead. I'm sorry I interrupted.
Your Honor, Ms. Vong Fachan has faithfully attended all of her court hearings. I believe that with added conditions of alcohol monitoring, that the court's concerns about her drink be suppressed. I know it's difficult to address the court's concerns about Ms. Vong Fachan's dishonesty. I believe she's come before you today and been honest about her past conduct and the conduct even after she was released from custody before court today. I'm asking the court to consider continuing her bond with those added conditions, as Vong Fachan will test today and tells me she will test clean.
Anything else?
Nothing further, Your Honor.
Not showing anything else.
No, I can speak. I just wanted to say sorry. I've made some mistakes that day when that happened. I didn't necessarily just kick in the door. It was more to it inside. And it just escalated. I was upset. I didn't mean to harm or disrespect Officer Cunningham. I didn't mean it for it to escalate that way. And I hope that I can apologize and make it right. I'm trying to. Since this has happened, it's my life is in shambles. I'm trying to figure it out. Being in jail I get to sit and think about my actions and, actually learn from them. But being in there, I can't get things done. I have to figure out getting another job, paying bills. Not that you care, but I'm trying. I'm trying to make it every court date. I quit smoking weed. If I could be placed on an alcohol tether or have to drop for, urine. I asked, can you still give me another chance?
And you said something very interesting. You said, I don't care. Not that I care.
Just now?
Yeah, that's a funny thing. Because actually, about everybody that comes before this court, I care. I do. Maybe sometimes to my detriment. I do. I don't understand your stupidity. I just don't get it. And you're asking me to give you another chance. You got the first chance when you were first out. Put you in. I bring you back. And you put me in a position where I can't give you another chance. So then you're in there another week. Told me that day, you and Mr. Feaster, you had learned everything and you were going to be able to conduct yourself by the court rules and everything else. You don't at 24 hours, you don't make it 24 hours. And you all think you just think that all of this is a joke. Don't get to just have your way because you want to have your way. Always. there's a bigger bully. But if you think I am going to tolerate this, wrong judge.
I know.
I do not like sending people to jail, but I'm going to do my job. And if you can't cooperate, if you can't just do the simple things that are asked, none of this stuff is hard. None of it. But if you've got to pretend to all these folks that this doesn't bother you and you're just too cool for any of this, you're just going to make it, well, okay, so be it. You can sit up there and be everybody's hero. So, Mr. Warren Green, here's what I'm going to do. I'm going to adjourn her preliminary examination. I'm adjourning her preliminary examination April 23rd, 2024 at 9. That is before me. It will give you the opportunity to certainly motion before this court this defendant's release, but for today, she's going. Defendant's bond is hereby revoked pending a motion hearing. If the defendant is released from jail, she will go on an alcohol screenshot.
Thank you, Your Honor.
They just took somebody back, so I can't. Mr. Warren Green, if you have that, you can set that on a Wednesday for any type of motion hearing on a Wednesday.
I will file.
You do that. It's on a Wednesday, so Miss Perroni and Miss no, Baresso's not going to help me. Miss Coons. Miss Perroni, Miss Coons can help you.